Hey class, today I'm going to review for you a generic organization of the U.S. and state judicial systems. This is again, generic review necessarily because there's 50 different states in America, each with some unique takes on their organization of their judicial system. And then there's the national judiciary, which has a specific organization that we're going to review. This chart is a overview of the entire judicial process. You have in this column the cases involving state and local laws, as we previously discussed, that proceed to a state trial court, which has original jurisdiction. If a litigant chooses to appeal, that would go to a state appellate court. If one of the litigants chooses to appeal that decision and the Supreme Court, the state Supreme Court, takes the case, it proceeds to that step. In very rare cases, a case can be appealed from a state Supreme Court to the United States Supreme Court, generally under a constitutional claim that this is some sort of violation of the federal or national U.S. Constitution. Similarly, a case proceeding at either involving a federal law, subject matter jurisdiction, or perhaps diversity jurisdiction, where there are two people from different states that are involved in a accident, for example, and the value of the case is more than $75,000, that establishes diversity jurisdiction. Those cases will proceed in federal court and proceed to the U.S. District Court system. And again, if there is an appeal by one of the litigants, it will proceed to the U.S. Court of Appeals for that particular region. And then again, the U.S. Supreme Court can choose to exercise its power to take that case, usually through a writ of certiorari, and consider the matter at the Supreme Court level. There are also special federal courts that have discrete subject matter venues, bankruptcy courts, court of claims, U.S. trade courts, that kind of thing. Those courts deal with very specific matters, and we'll talk about those here in a sec. But then they follow through the same process, going through the U.S. Court of Appeals, in most cases, on appeal, and finding themselves at the U.S. Supreme Court. Finally, there are a special, very rare category of cases where the U.S. Supreme Court has original jurisdiction. Remember, we talked in class about the distinction between original and appellate jurisdiction. Original jurisdiction is the trial level. Cases involving foreign diplomats, or government versus governments, border disputes, riparian rights, which are water rights, that kind of thing, will go directly to the U.S. Supreme Court for disposition at trial. So we're going to talk a little bit more about what happens at the trial level, the appellate level, and the Supreme Court level in this brief video. At the trial courts and the special federal courts, courts have original jurisdiction. This is where the court first hears the case. This is where a trial happens. Trials can be one of two types. They can be a jury trial where there is a jury. At the national level, there'll be 12 jurors. States can set the number of jurors that they have according to state statute or in their constitution. So you can have a jury trial where the jurors, the citizens called to that panel, will determine the outcome of the case. These are called the issues of fact, okay? The issues of fact are what happened, that kind of thing. They weigh the credibility of the witnesses, they consider the evidence and determine what happened. And then the judge in a jury trial functions kind of like a referee. The judge spends a lot of time riding herd on the lawyers in the case. ruling on objections to evidence, that kind of thing. So the judge will act as a referee, determining issues of law. Okay, whether that objection was appropriate, whether it's sustained or overruled, whether this testimony can be admitted into evidence, that kind of thing. Now, there's a second kind of trial as well. These are called bench trials. A bench trial doesn't have a jury. The judge sits as the trier of both fact and law. So the judge not only acts as referee, the judge also determines the outcome of the case. Okay, now again, criminal law is a little different. We'll talk about that in a later video. Now, of course, as I mentioned earlier, the decision of a trial court can be appealed. And now, if there is an appeal filed, the appeal asks for reconsideration of some aspect of the case. This evidence that was excluded, for example, could prejudice the jury, and thus the defendant didn't get a fair trial, or the losing litigant didn't get a fair trial. That might be the basis of an appeal. We'll talk about appellate courts here momentarily. In the federal special courts, these are specialized courts, as I mentioned earlier, military tribunals, trade courts, bankruptcy courts, that have a specific subject matter that's generally complex or unique in an area of law. The appeal process proceeds, they still have trials, all that kind of stuff. It's just original jurisdiction for a more specific area of law. Now, at the appellate level, there's no more trials. You don't have another trial. Courts with appellate jurisdiction only hear appeals from trial courts. This is really important to remember. They don't get to consider any issue that they want. They can only consider the issues. The appellate court justices can only consider those issues raised on appeal. They don't have a new trial. They look at the transcripts of the original jurisdiction court of the trial itself. They read the evidence. They read briefs from the attorneys that represent the two sides at appeal. And then they may hear oral arguments where the attorneys answer questions of the justices. The justices generally sit in at least a three-judge panel, a three-justice panel. And so if you're an attorney before a appellate panel, you've got to field questions from all of the justices, who are generally either trying to help you or hurt you, depending upon their reading of the case and the briefs. And they pepper you with questions and to expand on this particular area of law or that particular area of law that they are curious how you stand on, because that will influence perhaps their view of the outcome of the case. When they decide an issue on in an appealed case, they will either affirm the lower court's decision with a majority opinion. Again, remember, if there's three justices deciding a case, two make a majority. They may affirm the lower court's decision, saying, oh, nope, they didn't do anything wrong on this issue. The case is completed in their eyes, that it was properly determined. They may overrule the lower court's decision and remand it, return it to the lower level to either have a new trial or to consider that evidence and see if it would change the outcome. They may modify the lower court's action. They order a retrial before a new judge and jury because one of the litigants didn't get justice. They didn't receive the proper justice because of this mistake at the original trial. So there's lots of different things that can happen with an appealed case. Now, of course, cases can be appealed again to the U.S. Supreme Court. These are not mandatory appeals, though. Every litigant has the opportunity in civil court to appeal to the appellate level from the trial court. You have one mandatory automatic appeal. Anything beyond that is gravy, as they say. The U.S. Supreme Court picks and chooses what cases it wants to hear. So the U.S. Supreme Court is the final decision maker in the state and national court systems. It's the court of last resort. And they generally act in the vast majority of cases as an appellate court, hearing cases from either the federal or the state systems. They only take the most important cases. So, for example, a constitutional question is raised. This act is, or this law is not constitutional, for example. They may resolve a conflict between two appellate courts. The Seventh Circuit of Appeals, which includes Illinois, has interpreted a federal law one way. The Ninth Circuit, which includes California, has interpreted the same identical federal law differently. Well, that creates a conflict between the citizens living in California and how the law is applied there, and how the citizens who live in Illinois are affected by the same federal law. That conflict can't be left for long, okay? Because then somebody's not getting treated properly under the law. So a conflict between circuits might be taken by the Supreme Court as well. The Supreme Court justices will go through a similar process as the appellate courts. They hear appeals, they decide the case together. All 9 of them will hear oral arguments, and then they sit down and discuss the case, vote, and the Chief Justice assigns who's going to write the opinion of the case. The majority opinion, the concurring opinion, and again, the dissenting opinions. This has confused some of my students for years, and it's a really, really simple idea. Majority opinion, concurring opinion, dissenting opinion. Imagine you're with a group of your friends and you want to go see the movies. You want to go out to the movies. And there are 3 of you. And one of you wants to go see a romantic comedy, and you're discussing what movie to go see. Well, your friend who wants to see the romantic comedy really wants to see this particular actor that she loves. Another friend wants to go see the romantic comedy because it got great reviews. And you want to go see the newest Star Wars movie. Okay. So amongst the 3 of you, because your 2 friends who want to go see the romantic comedy concur in the outcome of the decision, which is to go see the romantic comedy movie, they have a majority of the 3 of you. Now, they don't have the same rationale or reasoning to get to that conclusion. One wants to see the Rocco because they really like this particular actor. The other one wants to see the Rocco because it got great reviews. Nevertheless, the outcome is the same. So they have a concurring opinion, different reasoning to arrive at a majority opinion. You want to see the latest Star Wars movie, but you don't have the votes. That means you get a dissenting. You are a dissenter. You disagree with the majority's view. That's kind of how Supreme Court justices will determine their views or opinions in a particular case. Okay. Last little bit, there's alternative forms of dispute resolution. We don't have to go to trial on everything. Alternative dispute resolution, or ADR, is something that's a possibility as well. Mediation, attempts to informally resolve dispute by appealing to a mediator, somebody who sits at a table, the 2 sides present their information, and this third party tries to kind of cut a deal between the 2 of them. Arbitration is basically like a trial. It's a little bit more relaxed, rules of civil procedure. You don't have to jump through all the hoops and everything like you're at trial, but an arbitrator will render their decision. The vast majority of cases in the American legal system, though, are resolved by settlement, where the 2 lawyers sit down, negotiate the case, and resolve the dispute prior to trial. Okay, see you guys in class tomorrow.